You have to make me as host.
Yeah, I'm
A very good evening to everyone, and I'm very pleased to bring to you yet another series of the webinar on a very important topic that we have been discussing from last two series, which is on the higher pension eligibility. And I'm happy to introduce to you Mahesh, who leads our subject matter expert team and has been instrumental in decoding this entire judgment and the impact of the various aspects that this judgment may have on various kinds of organizations, on employees, on employers, on different sectors that we have been working in, whether it will affect us, how it will affect us, and the kind of readiness that all of us need to be in line with the Hon'ble Supreme Court judgment. So without having more to do, I'll request Mahesh to please start with the proceedings so that we can have more and more knowledge share with our participants.
Definitely, yeah. Sumit, thanks for the setting the context. So I'll start sharing the screen. Hope my screen is visible to everyone.
Yes, Mahesh, please.
Once again, good evening, everyone. And this is our third series in respect of the webinar, and which is related to higher pension eligibility. And this has been a noise since the 3 months from the time the Hon'ble Supreme Court has given his, it has pronounced that the higher pension option can be exercised by certain category of employees. So that's when this has become a very hot topic, and this is our third session. And today we are going to have a detailed discussion as like earlier. And also we have come up with certain recent developments have happened in the month of April as well as in the month of March. And what all the updates have happened, we are going to highlight it. So more on to the index. So this is how I'm going to walk through the presentation. And firstly, I'm going to provide you what is the background of the higher pension and what is para 26.6 and the EPF scheme of the 26.6. And in addition to that, what is 11.3 under EPS, and what is the reason behind why every employee is now opting for a higher pension and why was not opted earlier. I'm going to also throw some light on the higher pension, what was the ambiguity, and Hon'ble Supreme Court, what has been pronounced in terms of the highlights of the Supreme Court judgment, which we are going to have a detailed discussion, and who are all eligible. So this parameter is going to be very important, and who are all eligible for higher pension, FAQ and illustration, which we are going to highlight it. And as I said, Kerala High Court has given an interim direction in respect of how employee has to exercise the option, and also certain guidelines has been provided to EPFO to simplify the process, so which I'm going to tell you in detailed way. And EPFO internal direction, which has come on 23rd April 2023, which also provided certain details to the internal department, how higher pension has to be approved, or in case of any deviation in the record submitted by employee, how it has to be taken care. So more on to the employee pension scheme. So what is this employee pension scheme? And this would be administered by the Employee Provident Fund organization, and this is one of the miscellaneous provision of Employees Provident Fund Act 1952. So this has been enacted on 16th November 1995, and this is one of the social security scheme administered by Employee Provident Fund organization, as I mentioned. So from the time the EPF has been introduced, the ceiling limit has been, like, I would like to also highlight about the ceiling part. What do you mean by ceiling in the PF? PF ceiling, when the pension was introduced, the PF, the ceiling was, which is 5,000 in the year 1995, and subsequently EPS or the PF ceiling has been enhanced. Subsequently, even pension also have been contributed accordingly. So now what is this pension and what is this para 26.6 and what is para 11.3? I would like to emphasize more, because we are going to have a more detail on this. And if we could understand what is para 26.6 and what is para 11.3, we would be able to understand the subsequent slide as well. So move on to the what is para 26.6 is, which is related to, there are certain establishment or certain industries, those who are contributing PF on higher than the prescribed ceiling limit. As I mentioned, PF shall be applicable to the capping which has been prescribed by the department. Anything if employee and employer willing to contribute beyond the capping, where the joint consent has to be submitted to EPFO. So the provision which clarifies or which depicts 26.6, which is related to joint consent, has to be submitted by employee and employer to the PF organization, depicting we are willing to contribute more than the prescribed ceiling limit, which has stated 5,000, 6,500 and 15,000, which has been time to time has been enhanced ceiling. And the same has to be approved by the not lesser than the APFC, which is Assistant Provident Fund Commissioner, which has to be approved, and the consent has to be obtained from the PF department. That is when we will have an empowerment to contribute on the higher than the prescribed ceiling. So move on to the what is para 11.3 under EPS pre-amendment. It is a erstwhile para where from 1st September 2014 onwards, the said para has been omitted, wherein this para has been, there is a provision in the prior to 1st September 2014, similar the way we have to provide a joint consent under para EPF scheme. Similarly, under EPS as well, the same joint consent has to be submitted where employee willing to contribute pension on the actual basic, which is beyond the prescribed ceiling limit, which is probably would be more than 5,000 or more than 6,500 in certain cases. And the current cases, it is going to be more than 15,000. So as I stated, why ambiguity raised in respect of the higher pension? So I'll again brief you where the ambiguity has been come into the picture. When employee were contributing, employee and employer together, I'll take you example of 30,000. If person was contributing on actual is PF wages or the basic wages on the 30,000, wherein the pension alone has been restricted to capping, either it is 5,000, 6,500 or 15,000, wherein he has not been allowed to contribute on actual. Since as per the para 11.3, where the consent has to be submitted, wherein there is no visibility to the establishment or to the employer or employee, there is no visibility. That is when even the employers were not aware of it, and that's when even they have deducted or they have capped it to 6,500. So that's when this issue has been come into the picture, and where such category of employees have reached out to the highest level, which is Supreme Court, and they have stated, despite we were contributing on actual basic, which is beyond the prescribed ceiling limit, however, we have been deducted EPS only to the capping. That's when we are also going to get our EPS payables are very less, which is limited to capping. So the ambiguity has been raised. As I stated, there's no enforcement from the PF department, despite they were receiving the PF contribution on an actual, which is more than the prescribed ceiling limit, wherein department has not enforced you to submit with the para under 11, the joint consent, and also under para 26.6, they have not enforced you to submit, and department also have not given any clarity in case if you don't submit this, you will not be entitled to receive for the higher pension. So this is when the clarity was missing, and all employers were contributing on to the prescribed ceiling limit. And also I would like to highlight one more point, which is very important to understand here, which is on 1st September 2014, the notification has been issued to enhance the PF ceiling from 6,500 to 15,000. In addition to that, where department has come up with the certain provisions which has been amended, where employee, in case employee joining as a first-time employee to the organization or to the PF membership, and he was not a part of EPF earlier, whose basic wages or the PF wages more than 15,000, he will not be eligible for pension. The entire amount has to be diverted to account number 1. Why I have highlighted this particular point is this will make you understand this higher pension shall not be applicable employees, those who have joined on or after 1st September 2014 as a first-time membership to EPF or the EPS. Provided they have also stated in case employee, those who are contributing on a higher side prior to 1st September 2014, And even after they wanted to continue to contribute on a higher side, there's a certain level contribution has to be paid by employee, which is 1.16% additionally on for the additional wages. As I said, 30,000, if you take an example of 30,000, the 15,000 capping, you are already contributing. Anything beyond 15,000, which is an additional contribution being made by you, for which the department has come up with that additional contribution has to be borne by employee, which is 1.16%. Move on to the higher pension. What are all the highlights from the Honorable Supreme Court, which was pronounced on 4th November 2022? Since there was no clarity after 1st September 2014 and many number of employees have been deprived from the benefit receiving the higher pension, so all such category of employees have been reached out to Honorable Supreme Court, and Supreme Court has pronounced its judgment depicting even now employee can enforce or exercise the option those who are eligible for a higher pension. It is not that nowhere in the act it is prescribed. There is a time limit for you to exercise option. That's when the Supreme Court has pronounced its judgment depicting from the date of judgment, the 4 months window period has been extended to all such category of employees to exercise higher pension option. So that was due by 3rd March 2023, wherein the PF department has not provided, like they have not introduced any online portal or subsequent, like they have not provided any the option for employees to exercise. That's when even department has extended another 2 months of time. Now currently the due date for the submission of or exercising the higher pension option has been extended to 3rd May 2023. So what all are other the judgment has stated is exercising the joint consent, and also they have stated the paperwork based on the Supreme Court judgment, the paperwork or anything which the department has to come up with the 8 weeks from the date of judgment, wherein however the department has delayed it, and the final the communication has come on 20th February 2023. And further, they have also kept this 1.1, which I have stated earlier, in case if employee would like to contribute on a higher side. Additionally, they have to contribute 1.16%, which the department has kept, like the Supreme Court has informed to the department that it is going to be, like it kept on abeyance for another 6 months from the date of judgment. They have also, like Supreme Court also directed the PF department to come up with the proper justification. Why this 1.16% has to be collected from employee? Why not this will be within the board? EPS board can be adjusted. Otherwise, it may collected from the employer. So they have asked us to provide the proper justification or the proper substantial proof to collect it from employee. That is when even this 1.16% will come into the existence. So we have a timeline till 3rd May 2023. Within that, the department has to come up how they are going to manage with 1.16%, which the additionally where employee has to pay currently. And higher pension option, earlier there was a notification issued by PF department depicting higher opting for a higher pension option shall not be applicable for exempted establishment. What do you mean by exempted establishment? Is exempted establishment those who are obtained the exemption to operate the EPF corpus within the company, and the certain organization have been exempted. For such category of industries, they have stated that higher opting for a higher pension shall not be applicable, wherein Supreme Court has stated they're as good as the unexempted establishment and they have been contributing equal percentage of contribution, and this shall be applicable to even exempted establishment as well. So these are all the major highlights of the Honorable Supreme Court, which has been pronounced on 4th November 2022, which is with regards to higher pension. To move on to this slide, I have made a couple of scenarios here to make you understand what is this higher pension and how it is going to be applicable. Scenario 1, which clearly talks about employees, those who have left the organization prior to 1st September 2014 and those who are contributing on higher side. So what would be the eligibility criteria? In the scenario 1, I have 3 classification. One is employee who's contributing on higher side, and he has exercised the option, as I mentioned in my earlier slide, where the para 11.3, in case if the employee would have submitted to the department and in case the respective claim has been either accepted or not accepted by the department, or they have not at all responded, for such category of employees, what would be the scenario? So when it comes to the first scenario, and the classification of first one is related to employee was contributing on higher side, which is prior to 1st September 2014. The capping was 6,500 at that point in time, and he has not exercised the higher option. And he has also not submitted any joint consent to the department whether such category of employees will be applicable. So here he is not exercised and he has not submitted anything in for such category of employees. The Supreme Court has very clearly stated in 44(5), they have stated that such category of employees shall not be applicable for higher pension. They will continue to get the pension what has been declared existing currently, the same amount, otherwise they will not be entitled for the higher pension. Coming to the another scenario, which is employee was contributing on higher side, wherein he has exercised the option, which he has submitted erstwhile para 11(3), he has submitted to the department, wherein department has not provided any clarity to them, or they have not responded to the joint consent, whether such category of employees shall be applicable. Yes, that category of employees can now exercise their option, provided they have to upload the acknowledgement which was submitted earlier to the department, despite if they have not given any response. Another set of category here is employee was not contributing on higher side, which is not beyond either 6,500 nor 5,000. He was contributing only to the capping or less than the capping. Such category of employees anyways not coming to the picture of higher pension, since they were contributing 8.33% of the actual basic. Move on to the scenario 2. What is scenario 2? Here I have come up with the employees, those who were contributing prior to 1st September 2014, even after 1st September 2014, but mid of somewhere they have left the organization. But however, this category of employees also, those who have left the organization in recent past or on or after 1st September 2014, this scenario who are all applicable. The applicability part, again, the first applicability, employee was contributing. The criteria is the employee was contributing on higher side, wherein he has not exercised the option. Whether he is eligible? Yes, he is eligible. And another category, he has exercised the option and he is also contributing on higher side. Whether he is eligible? Yes, those category of employees also eligible for opting higher pension. The third category, as I said, is contributing either to the capping and less than the capping. Such category employees will not come into the higher pension eligibility. So these two categories are eligible, and the due date for exercising the higher pension, which is on 3rd May 2023. This scenario 3, is going to be very important for all the audience, those who are part of it here, since these employees they are continued to be serviced now. They exist, currently they are working and they were contributing prior to 1st September 2014 on the higher side. Even today they are contributing and still they are in the service. So here I have made 4 classification. The first classification is the employee was contributing entire his tenure. This is very, very important. During his entire tenure, where employee was contributing on higher than the prescribed ceiling, and he has not exercised, or he has exercised the option, whether such category of employee shall be applicable. Yes, he is going to be applicable for opting for a higher pension. And another category, yes, he was contributing on higher side, wherein he has not exercised the option, which is para 11(3), as I stated. He has not exercised, but however, such category of employees also will be applicable for opting for higher pension. The third category, he was contributing only to the capping. I have come up with this scenario. It is going to be a common in all my 3 scenarios. But however, I wanted to clarify the employee even today prior to 1st September, he was contributing only to the capping or less than the capping. Such category of employees anyways will not come into the ambit of higher pension. So move on to the fourth one here. Employees, those who have joined. This I have also reiterated in my earlier slide. Employees, those who have joined on or after 1st September 2014 and whose basic wages is more than 15,000 and it is a first time membership to the EPF, such employees will not be a part of, they are not eligible for pension. The entire amount, which is 12% of employer, has to be diverted to account number 1, which is the entire 24% will be accounted in the EPF corpus. So here I have given certain example which will throw you you will be able to understand how much am I going to get pension if I am going to contribute only to the capping, and how much am I going to get in case if I'm going to contribute on an actual if I opt for a higher pension. So I've come up with a table here. The table first which depicts is employee basic wages of the PF wages is 15,000 and he has put in a service of 20 years. And what is the pension payable? Now currently, this is a rough calculation. There could be a slight variation based on the earnings by the employee, but here I have taken the wage ceiling as 15,000. And also I would like to highlight how the pension would be calculated. The pension would be calculated your last 5 years, which is a 60 months average EPS wages into number of years you have served or you have put in, divided by 70, which is a lifespan. So I have considered this formula. Based on that, I have calculated and I have come up with the table. And here the employee basic was 15,000 for the last 5 years, and he has a put in a service of 20 years, and the pension payable will be 4,286 rupees he would be getting for the existing. Now, currently, all employees are contributing on higher side. Those who are not contributing on higher side, so you will be eligible. And similarly, in case now, since your basic is 80,000, wherein your pension has been only restricted to 15,000 and you are contributing only to the 15,000. Now you are opting for a higher pension, where you are requesting PF department, my basic is 80,000 and I have to be contributed 8.33% of 80,000, then what would be the pension? So I've taken the same, the number of years of service here, 20 years, and the person shall be entitled to get pension from the department, which is 22,857. And what is the difference of amount which he is going to get once he is going to opt for the higher pension, which is 18,571. The number is huge. Similarly, if person whose basic was 40,000 or the average EPS for last 5 years is a 40,000, then he will be getting 11,429 in place of 4,286. And the difference again, 7,143. Similarly, if person 20,000, I have come up with 3 examples here. So the difference would be 3,857 in this case. So this is, we will only look at it, how much pension am I going to get higher side, but at the same time, you should also understand how much amount which you have to divert from EPF corpus to pension corpus, that the table 2 which would clarifies to you. Now say for example, now as I mentioned, the person was, the basic wages was 15,000 and he has put in a service of 20 years. The pension, how much he would have been contributed to pension account, which is 2,99,000 to receive the pension of 4,286. If I opt for a higher pension and 80,000, if I take the approximate number, then the pension you supposed to contribute 15,99,000. Since you have already contributed 2,99,000, the remaining balance of, which is in the last table, 12,99,480 rupees additionally you have to divert from your EPF account. From your EPF corpus to you have to divert. That is when you are entitled to receive higher pension, which is 22,857, as I mentioned in the first table. Similarly, if person is getting 40,000, I made the difference where you have to divert the amount of 4,99,800. Similarly, if it is a 20,000 case where he has to pay back 2,69,892. I mean to say payback means which is an internal adjustment from the EPF corpus to pension corpus. So when the diversion happens, the amount what you have contributed towards the pension, you will not be entitled to withdraw it. Wherein if it is an EPF corpus, any given time, you will be able to withdraw it. For example, now 12 lakhs, now you have opted for a higher pension and you wanted to get more pension. So that point in time, you will have to contribute this 12 lakhs or 12,99,000 you have to contribute, but which is not, you can't withdraw it because pensionable amount cannot be withdrawn. Wherein if this amount, which is accounted in the EPF account or account number 1, that can be withdrawn at any given time, and that is going to be your corpus. If once it is diverted to pension, it is not going to be. So that's when I would request you to, the individual has to take a decision whether it is really going to help me or it is going to be help me in terms of increasing my financial support, and accordingly you have to take. That is when I have come up with a detailed table over here. So this corpus cannot be withdrawn, and at the same time, in case of uncertainty to the employee or the pensioner, the the pension shall be payable to nominee only 50% of what is being paid here. For example, if person is opted for higher pension and is getting 22,000. So in case of uncertainty to the individual, then the nominee is going to get only 50% of 22,000. So, and he will, like, even nominee shall not be entitled to receive or withdraw the pension amount. And in case of any uncertainty to nominee, then no, the pension would be paid only to the children. In case if they are orphan, pension would be paid. That is again, the certain age limit has been fixed. What would have happened by then? You attain 58 years of age, your children would be more than 20-25 years. Even they wouldn't be eligible for pension. So that criteria also has to be taken into the picture before you are going to opt for a higher pension. So I'll move on to the next slide, which I have provided certain FAQ based on the queries we have been receiving it from our esteemed clients. In addition to that, we have also received from our internal team. So we have collated everything, and I made certain questions here to make you understand how it is going to be applicable. Or if you have any questions, I think you will get the answer from this FAQ. So the frequently asked question, which is this, whether those who are retired before 1/9/2014 can opt for a higher pension. As I mentioned, yes, a person contributing on higher side, and he has exercised the option, which is under para 11(3). If he has exercised the option, yes, he is eligible. Otherwise, if he is, though he was contributing on higher side, if he has not exercised the option under para 11(3), he wouldn't be eligible. So move on to the question number 2, whether those who are retired on or after 1/9/2014 are eligible. Yes, I have given the scenario 2, which I have also highlighted. Such category of employees also eligible, provided they were contributing on higher side, which is prescribed the ceiling limit of the PF. Whether those who are presently working can opt now. Yes, they can opt now. And if the condition is satisfied with the second question, which is they have to contribute on higher than the prescribed ceiling limit. Whether those who have joined after 1/9/2014 and it is a first time employment, which also have cited, such category of employees will not be eligible for pension. So higher pension point itself does not arise here. So what is para 26(6), which I have already clarified, which is a joint consent has to be submitted by employee and employer to the RPFC, depicting that we are willing to contribute on higher than the prescribed ceiling, employer and employee both. Whether option under para 26(6) is compulsory for opting now. Yes, for any employee who joins, those who are contributing on higher than the prescribed ceiling, I would request you to collect, or you have to submit a joint consent, because now department has made this 26(6) for exercising your higher pension, and this has become one of the major concern for each and every employee, those who are eligible for higher pension, where they are not having this consent, to upload in the portal which has been provided by the department to exercise the option, wherein many number of employees are not having. But however, department has certain, few department has given an interim relief that they are accepting this 26(6) joint consent even now, and you can get this submitted to the department, get an acknowledgement copy, and thereafter you can upload in the portal for exercising your higher pension. What is para 11(3)? As I stated, it is one similar para what is prescribed under EPF, which is 26(6), the joint consent, similarly 11(3), but however, this has been omitted. And in case if employees, those who have submitted based on the 11(3) earlier, so such category of employees can upload the acknowledgement which was submitted to the department. Move on to the question number 8. What is para 11(4)? 11(4) has been introduced from 1st September 2014, and they have also cited in the notification for September 2014 notification, depicting those who are contributing on higher side, which means they are beyond, whoever contributing more than the prescribed ceiling limit, and they are contributing 8.33%. Even such category set of employees were there. It is not that none of them were contributing 8.33 of their actual basic. There are certain category of employees who are contributing it. And for those category of employees, department has given a window period. On 1st September 2014 notification has given a 6 months of window period for them to exercise that option to continue to contribute even after 1st September 2014. And another additional 6 months has been extended to them, depicting in case if there is any deviation or if there is any concern in the document submitted by the department or by the employee. So another 6 months window period, additional 6-month window period has been extended. So this is what is a para 11.3. If a member who had opted under para 11.3 and not renewed his option within 1 year, what will happen? So this is, if he has not, though, if a member who had opted under para 11.3 not renewed his option under para 11.4 within 1 year, such category of employee shall not be eligible for opting for a higher pension, and same shall be cancelled. If a member opted under 11.3 and not renewed his option under 11.4 within 1 year, can opt now? No, even such category, because on 1st September 2014, department has given a sufficient timeline to exercise the higher option for such category of employees. 6 months. In addition to that 6 months, another 6 months in case of any dispute in the document. So that's when for such category of employees, department is not extending, and who are all not eligible for higher pension. Now, as I stated, those who are contributing on actual capping or less than the capping, those category of employees will not be eligible, and those who have joined on or after 1st September 2014, and if their basic wages or the PF wages is more than 15,000, those employees also will not be, and as per the para 11.4 as I stated. So these all category of employees shall not be eligible for opting for higher pension. What is the timeline extended by Hon'ble Supreme Court? As I mentioned, Supreme Court has extended 4 months timeline, which was 3rd May 2023, which is 6 months, as I mentioned. Actually, the Hon'ble Supreme Court has extended 4 months, wherein due to delay from the department in providing the information how the higher pension has to be exercised, that's when department has given another 2 months of time extension, and the due date is 3rd May. And in case if like the employers, those who have not exercised, or employers, those who have not intimated, I would request them to immediately take up, because we are very close to 3rd May 2023. Employees, those who have had worked in multiple companies, can they exercise the higher pension? So this is one more important question, because employees would have worked in a multiple company, and this is prior to 1st September 2014, and even after 1st September 2014, collectively it is going to be more than 10 years of tenure. So such category of employees, whether they are eligible, yes, they are eligible, provided they were contributing on higher than the prescribed ceiling limit in all his organization or during his entire tenure. Frequently asked question in number 14, what if employee contributed to PF ceiling in one of the company tenure and other company above the ceiling? It is again a vice versa. So there are certain organizations, they will not allow employee to contribute anything beyond the capping, which is 15,000, either 15,000 or 6,500. What would happen for such category? In one organization, you might have contributed more than the prescribed ceiling limit, wherein in a couple of organizations you might have contributed only to capping. So such category of employees, what would it? Though department or the Supreme Court has not provided clear guidelines, but when we had a discussion with the PF commissioner, he has stated such category of employees shall not be eligible for opting for higher pension. Since in any of the tenure, in case if the contribution made only to the capping or less than the capping, those category of employees will not come into ambit of this higher pension. What if employee had a break in service? If the employee had a break in service, only shall be considered as a non-contributory payable days, but he will continue to get the benefit, or he can also opt for the higher pension. What if employee availed partial withdrawal? So this is one more important question is from the EPF corpus, many of the employees would have gone for a partial withdrawal based on their eligibility after completion of 5 years of service, either for purchase of flat or plot, or for a medical grounds, or for a schooling purpose of their children. So what would happen when you exercise the higher pension? Now the corpus has to be diverted from EPF to pension. So if there is any deficit from the EPF account, then the department will inform to you that so much of amount has to be paid back to the PF department for you to get a higher pension. So this is very important. As I mentioned, in case if you have withdrawn certain amount, the same amount has to be paid back to the department, since your EPS corpus will have a shortfall and the deficit has to be paid back. Does the employee has to additionally contribute 1.16%? Yes, all this while the employee was contributing on 1.16%, those who are contributing on higher side, wherein this has been kept it on abeyance for 6 months. where Supreme Court has given the direction to the EPFO to come up with the proper justification why this 1.16% has to be collected from employee. So based on that directions or based on the justification from the PF department, so we can take it up, either it is going to be an employee additional liability, or it is going to be employer liability, which will be clarified by the PF department shortly. Whether exercising higher pension by eligible employees are a mandatory. This is also very important, whether it is mandatory. It is not mandatory. If you're not willing to go for a higher pension and you wanted to only contribute to the capping, despite your PF is going on a basic wages, wherein your pension alone has been restricted to the capping, you can continue to do now. And the timeline which has been extended by 3rd May, if you are not going to exercise, then you will not be entitled to opt for a higher pension. Then you will continue to go with the existing process. Otherwise, it is not a mandatory. What is EPS calculation formula, which I have stated last 60 months, which is a 5 years of average EPS wages into number of years you have served, and the 70, which is the lifespan of the employee, which is approximate lifespan has been considered. So move on to the certain direction has been provided. As I mentioned, when employees are opting for or when they're exercising the higher pension, the 26(6) joint consent is one of the mandatory document has been made by the department, where each and every individual or the employees, those who are eligible for higher pension, they have to submit the acknowledgement copy, wherein none of the employees or none of the establishments have been submitted. That's when many of the employees who have reached out to Kerala High Court, and Kerala High Court has given a certain guidelines to the department, which has come on 12th day of April 2023, and I have come up with the summary what the Kerala High Court has cited. One thing they have cited is joint consent of 26(6), which is not submitted by employer, either capping of 5,000, 6,500 or 15,000, has been accepted by EPS. See, like EPF, the once EPF is receiving the higher side amount, which is deemed to be accepted, this 26(6) has been accepted even in one of the notification issued by the PF department in 2016. If you do not submit the 26(6) joint consent, wherein you are contributing on the higher than the prescribed ceiling limit, which will be deemed to be submitted 26(6), but wherein subsequently they have withdrawn the notification. But however, the Supreme Court Kerala High Court has highlighted this. Asking for 26(6) currently may not be the right way for employees to opt for a higher pension. And another direction which has been given by the Kerala High Court, that the adequate facility which shall not have the 26(6). As I stated, 26(6) shall not be there when employees are exercising the option. Otherwise, it will defeat the purpose which has been pronounced by the Hon'ble Supreme Court. And if appropriate modification in the portal, in case if the appropriate modification can't be made, what needs to be done? They have stated feasible alternative arrangement has to be provided, or they have to provide an option employee to submit manually. So all such options they have cited in the Kerala High Court. And the facility cited in the interim order shall be made available to all employees and pension within the period of 10 days. They have also cited that the directions which has been provided by Kerala High Court within 10 days time, where the PF department has to clarify or come up with all this process or simplifying the process or not making 26(6) as a mandatory document. But however, from 12th, the day the Kerala High Court has given an interim direction, but so far department has not come up with any clarification. So we will have to wait for it. Otherwise, as of now, there is no further clarification from the PF department. More on to the recent notification which was given on 23/4/2023 by the PF department, but this is not for the employers, and this was issued only to the internal department, to the PF within internal department, and stating they have also categorized as a 3 parameters when employee exercise the option, and if the documents are good to go. So what needs to be done by PF department is one parameter they have cited, and another parameter they have cited in case the documents have been submitted by employee, wherein due to various reasons employer has not approved it. So what needs to be done for such category of employees? And another one, employee himself has uploaded certain documents which is erroneous documents or which is inappropriate documents have been submitted. So what needs to be done? So for all such three categories, department has going to scrutinize the document, and wherever the documents are good to go and he is eligible or he or she is eligible for higher pension, department will give a confirmation either through a message or through a letter depicting that you are entitled for the benefit. And at the same time, in case if any amount to be paid back to the department, as I mentioned, in case of any deficit, the amount also will be calculated by the PF department and same shall be intimated to employees. In case employee has not approved certain documents or certain claim are submitted by the employee, so department is going to give a list to employer and seek for the clarification why this was not submitted, and they would provide a month time for them to come back and clarify it and completion of that the approval. So the 1 month time would be provided. And similarly, employees, those who have submitted the documents, due to various reasons, there is some documents which are not appropriate or may not be relevant. For such category of employees, they have stated that we will provide another month for them to correct their documents and again submit to the department either offline or online. That shall also be communicated by the department accordingly. So this is the recent development. One is the Kerala High Court and other one is the EPFO internal circular stating how they are going to take it up, the employees, those who have exercised their higher pension for getting the higher pension.
Right.
So here the question and answer, Rahul, I'll just, you write to us for if you have any more questions. I'll keep the slide for maybe 2 to or maybe 4 to 5 seconds. You can make a note of it, and if you have any questions, you can raise it. But at the same time, I would also take it up for certain question and answers. I could see there are 15 question and answers. Questions are there. I'm happy to answer such questions.
I think, Mahesh, I think you have elaborated many finer aspects of the judgment of Honorable Supreme Court, and certainly, the kind of practical implications that our employees and the employers can align with the direction that and the judgment that Honorable Supreme Court has given us. We are more than happy to help specific companies and specific cases where we need more detail and more fine tuning. But Mahesh, you can have a few answers. There are 16 questions, but whatever are the few answers that you can, maybe 1 or 2 answers which may be helpful for many of us who are attending this webinar, may be helpful. In the rest, we can respond appropriately.
Definitely, Sumit. I'll take up a few questions. Hitesh Danak has raised a question. How is service continuity is defined? Example, if I had left my previous job in August 2016 after serving 8 years and joined current job in 2017, am I eligible? Yes, you are eligible, provided you would have been contributed on prescribed above the prescribed ceiling limit. And during this non-contributory, like during your break-in service shall be considered as a non-contributory payable days. And more to the next question by Mayur. Employer has to scrutinize the document and post it will reach out to the PF department for the final validation. Manish Sharma has raised, hi, will you send a webinar recording? I think the webinar recording has already been recorded. And I think we would be publishing it in YouTube. So any given time you can log in you can.
Yeah, we can filter it and we can let you know. But any specific questions, yes, feel free to ask us on info.hrtech@teamlease.com.
Yes. Contribution on above the ceiling limit by employee and employer, 5,000, 6,500 and 15,000. Does this mean EPF contribution or EPS contribution? Anything. The ceiling is, yes, it is a EPF contribution, but there are certain category of employees, those who are contributing above the ceiling, which I have prescribed, which you have prescribed here. So if you're contributing an actual basic, which as I mentioned, 30,000, wherein the pension alone has been restricted to either it is 5,000, 6,500 or 15,000 time to time, then you can opt for a higher pension. So move on to the next question, which is Srinivas B. Hi, is pension formula is finalized since there is no mentioned in guidelines? I'm not getting the pension formula is last 60 months, or it is a 5 years into number of years served and divided by 70, which is a lifespan.
Right. So maybe Mahesh, rest of the questions in the interest of time, we can respond to the respective participants who have asked these questions, and certainly we as Team Leads HR Tech would want to help, and each one of the companies and the groups which require to elaborately have a specific response or a specific output when they can leverage this particular judgment for the benefit of their employees and the employers, will be more than helpful to we'll be more than eager to help you in this. Please feel free to contact us, and in other questions also, please write to us. We'll we'll respond to that. So thank you, Mahesh, for this elaborate session. And please also write to us if you require any specific topics or any special sessions on any specific things apart from this. We will make our best effort to bring that topic to you, decode many things there as far as labor compliances is concerned, and see that how we can together add value to your business. So thank you each one of you. Thank you, Mahesh.
So, Sumit, thank you so much.